The House will please come to order. I'd like to thank one of my colleagues, my generous colleagues, for my afternoon snack. All right, members, thank you. Let's please come to order. Chief Clerk, please call the roll.
Convening roll call for the fifth day of this special session, Wednesday, November 3rd, 2021. Andrew. Baker. Banks.
Here.
Bear. Blackburn. Brown. Burkhart. Burt. Clausen. Connolly. Crago. Duncan.
Here.
Eklund. Air.
Here.
Flitner.
Here.
Fortner.
Here.
Gray. Gray. Greer. Greer. Hallinan. Haroldson. Harshman. Excused. Heiner. Henderson. Jennings. Kenner.
Here.
Knapp. Larson Lloyd. Larson Dan.
Here.
LeBeau. McGuire. Nyman. Newsom, excused. Nicholas. Oakley.
Here.
Obermuller.
Here.
O'Hearn.
Here.
Olson. Ottman. Paxton. Provenza. Provenza. Rodriguez Williams. Romero Martinez. Roscoe.
Here.
Schwartz. Sherwood. Simpson.
Here.
Summers. Stith. Stivar. Sweeney. Walters. Washut. Western.
Here.
Wharf. Williams. Wilson. Winter. Yen. Zwanitzer. Mr. Speaker. We have 58 present, 2 excused.
Thank you, Chief Clerk. I think Chief Clerk will have some messages here in just a moment, but first we'll do a privilege from the floor. Representative Yin,
Mr. Speaker, privilege of the floor.
please proceed.
Mr. Speaker, thank you, members. So I think we have an esteemed guest here. She's a constituent of mine when she is not at the University of Wyoming. And she is also the daughter of the good senator from Teton County on the other side. I'd like to introduce you to Malu Guru.
Well, welcome to the House. We miss your father when he used to be down here with us, but glad he's doing something at the other end. All right, so members, the Chief Clerk is reminding me that she did send out an email that has the concurrence message in it and the language, so that should be available to you. We'll be taking up that concurrence fairly certain. So Journal Committee report.
Mr. Speaker, your Journal Committee reports that the Journal of October 29th, 2021 has been read and recommend that it be approved. Signed, Representative Provenza and Representative Haroldson.
Thank you, Chief Clerk. Messages from the Senate.
Message 103, Mr. Speaker. Following successful reconsideration of the third reading vote, the bill listed below failed to pass the Senate third reading by the vote indicated. House Bill number 1001, COVID-19 vaccine employer mandates. Ayes 14, noes 13, excused 3. Sincerely, Ellen Thompson, Senate Chief Clerk. Message 105, Mr. Speaker. House Bill 1002, Federal COVID Vaccine Mandate Prohibition and Remedies Number 2. The House bill listed above passed on third reading in an amended form as follows, followed by the vote indicated. Ayes 20, no 6, excused 4. The Senate respectfully asks the House to concur by adopting the listed amendments. Sincerely, Ellen Thompson, Senate Chief Clerk.
Thank you, Chief. So members, as you've heard, we have one bill for our consideration on concurrence with Senate amendments. And we'll take that up now. The first message for our consideration is message 105 on House Bill 1002, Chairman Olson.
Thank you, Mr. Speaker. I do move message number 105 on concurrence. I don't know that I'm not going to ask for your favorable consideration, but I'm going to turn over the explanation of the concurrence to the good majority floor leader, Representative Summers.
Thank you. So members, let's recall that we're on concurrence, which is the same as a second or third reading debate rules. So first we'll have the explanation from Representative Summers, and then it'll be first time, second time, closed out by the majority floor leader. So with that, for your first time, majority floor leader Summers.
Mr. Speaker, thank you, ladies and gentlemen of the 66. I'm going to ask for your non-concurrence, so to vote no on concurrence. And I'm going to walk you through the bill. Page 1 is just cleanup on the title, on the long title. Page 2 goes into the findings and adds the 45th and the 46th presidents. Page 3, line 10, strikes in the upcoming days or weeks. I think the idea behind that was nobody knows when that federal rule may come into play. If we go on to page 4, it replaces entities with employers. If we go on to page 5, basically in Romanet 11, it would now read Article 1, subsection A of the Wyoming Constitution provides that each competent adult shall have the right to make his or her own healthcare decisions. And then there's a change in Romanet 12, and it is the Wyoming Constitution provides that and then there's quotation marks, legislature may determine reasonable and necessary restrictions on the rights granted under this section to protect the health and general welfare of the people or to accomplish the other purposes set forth in the Wyoming Constitution, basically just cleanup stuff. And then there's an addition in here or a replacement of what would be Romanet 13, Article 1, Section 38, subsection D of the Wyoming Constitution provides that the state of Wyoming shall act to preserve these rights from undue governmental infringement. And so that was a second reading on the second reading amendment number 1 in the Senate. And then there's a bunch of reordering. So each Romanet gets reordered throughout. Then we drop down to Romanet, and then we create more Romanets in Romanet 17, 18, 19. And I will basically walk you through them and read them. So Romanet 17 would be under the separation of powers. The federal government may not simply commandeer the legislative process of the states by directly compelling them to enact and enforce a federal regulatory program, while Congress and the federal executive branch have substantial powers to govern the nation directly, including in areas of intimate concern to the states. The United States Constitution has never been understood to confer upon the federal government the ability to require the states to govern according to the instructions of the federal government. Goes on with Romanet 18, our system of government rests on what might at first seem a counterintuitive insight that freedom is enhanced by the creation of two governments, not one. For this reason, the United States Constitution has never been understood to confer upon Congress nor the federal executive branch the ability to require the states to govern according to their instructions. Otherwise, the two government systems established by the framers would give way to the system that vests power in one central government and individual liberty would suffer. And Romanet 19, the directive issued by the federal executive branch and the forthcoming rules by federal agencies regarding COVID-19 vaccination mandates cannot be more direct affront to the state sovereignty. The state of Wyoming rejects these devices by the federal government under the anti-commandeering doctrine. This doctrine is simply that of a fundamental structural decision incorporated in the United States Constitution. The decision to withhold from the federal government the power to issue orders directly to the state, conspicuously absent from the list of powers given to the Congress is the power to issue direct orders to the governments of the state. The anti-commandeering doctrine simply represents the recognition of this limit on federal authority. And then, Mr. Speaker, this amendment, which this was a second reading amendment number 3, Senate second reading amendment number 3, basically creates a resolution in subsection B. So subsection B would be a resolution within this bill. And it goes through several Romanettes. I'll start out and maybe finish, but I believe you all can read probably faster than I can read it aloud. But Romanet I, the legislature strongly condemns the promulgation of any federal COVID-19 vaccination requirement or mandate as an infringement on the rights of the citizens of Wyoming to make their own healthcare decisions without governmental coercion, intrusion, or dictate. The federal government does not have the right to impose such mandates on the state, and doing so violates the 10th Amendment to the United States Constitution and Article 1, Section 38 of the Wyoming Constitution. And then, Mr. Speaker, if you roll down, I'll do the last one. Romanet 6, the Attorney General is empowered to initiate or participate in litigation and to take any other appropriate action to challenge and resist federal COVID-19 vaccine mandates or requirements that are contrary to federal and state law and that infringe on the rights of Wyoming citizens. And Mr. Speaker, then we go on page 6 on into section 2. You see the definitions. And then, Mr. Speaker, substantive change was Senate Standing Committee Amendment number 1 on page 7 that puts it back to the original bill that a public entity means as defined by 166101A Romanet 8, which and then it would strike the rest of it, except that public entity does not include an entity receiving federal funding. So that all goes away from that period that would be placed there on. And then, Mr. Speaker, you go on down to the bottom of the page and subsection C, we had a lot of debate on this, and subsection C would now say the following. It would say, except as otherwise provided in this section, subsection B of this section. So let's go back and read subsection B so folks can remember. So subsection B is no public entity shall enforce any mandate or standard of the federal government, whether emergency, temporary, or permanent, requires an employer to ensure or mandate that an employee shall receive a COVID-19 vaccination. So that section stays the same. And then subsection C, except as otherwise provided in this section, subsection B of this section shall not be enforced until the date of final disposition or resolution, including during the pendency of any appeal and any period between the entry of a judgment or mandate and an appeal of the judgment or mandate of all federal litigation concerning COVID-19 vaccine mandates that conflicts with subsection B of this section. So basically, subsection B goes away through entire litigation. Remember, our section said that the state law would stay in place through a stay. This says as soon as there's any litigation, even the pendency of litigation, then subsection B is basically goes away. And then subsection D goes on to say, notwithstanding subsection C of this section, subsection B of this section shall be enforced. So this is when it shall be enforced. And it goes when all conflicting federal laws, regulation, rules, standards, or orders are repealed, withdrawn, suspended, or declared. So in other words, the state law would come back in if federal rule, order, law was repealed. And then And then, Mr. Speaker, they strike our subsection E and they replace, and in just a moment on that, having talked to the other body, they had a whole debate. E was kind of a placeholder for a bill that failed over on that side. And they felt that they had that debate, didn't want to rehab that debate. So they took out our E and put in place of it, nothing in this section shall prohibit a public entity from applying for a federal grant or a federal reimbursement and verifying compliance with a federal COVID-19 vaccine mandate until subsection B of this section becomes enforceable under subsection C or D of this section. And then, Mr. Chairman, we go on down that page to line 13, section 3. And that section 3 now becomes that was in the original bill now becomes part A. And then their standing committee amendment number 1 put in a part B. And this says litigation under this section may include initiating an action in the name of the state of Wyoming as a party aggrieved by a violation of the 10th Amendment or other protections reserved to the states under the United States Constitution involving egregious federal overreach into rights reserved to the states and asserting standing on additional grounds, including that the state accepts federal funding and federal contracts and is therefore injured by federal threats and coercion to withhold federal funding, which constitute an unconstitutionally coercive exercise of federal spending. And then Romanet 2, and this is one of the reasons I think we need to visit on, whether the AG has this authority or whether we should grant this authority. And that is on private lawsuits. So Romanet 2, initiating a class action lawsuit on behalf of the state of Wyoming as the lead or other plaintiff, and that may allow Wyoming citizens to join the lawsuit as members of the affected class of those personally injured or whose livelihood is negatively affected by federal vaccine mandates. And Mr. Speaker, then we move over to page 9, and I hope I haven't missed anything. And maybe I missed something right. I think I missed something right there. I had it underneath my flap. So on page 8, Mr. Speaker, section 4, they changed our $250,000 appropriation to $10 million. And the idea was that if we were going to enjoin some class action lawsuits, that might take a larger pot of money than $250,000. And then, Mr. Speaker, we go on and have a new section 5. This was Senate second reading amendment number 3. The Wyoming Secretary of State shall transmit copies of this act to the President of the United States, Speaker of the United States House of Representatives, the President and the President Pro Tem of the United States Senate, the majority and minority leader and whip of each House of the United States Congress, and to Wyoming's congressional delegation. And then finally, Mr. Speaker, section 5 in the current bill would become section 6 with renumbering. So I went through that pretty fast. Once again, I'm going to ask for your no vote on concurrence for a couple of reasons. One is we need to visit a little more about that authority to work a private lawsuit, class action lawsuit. And then I think there is some debate on whether 10 million is too much or not. And so that's why I will ask for your no vote.
Thank you, Majority Floor Leader. Any members wish to speak to the concurrence? First time on the concurrence. Chairman Wilson, first time on the concurrence.
Thank you, Mr. Speaker. I'm also going to vote no on the concurrence, although I would have to say that my reasoning is, and I don't care one way or the other really about 10 million, which is a horrible admission from an elected official, but I think I'm actually okay with us helping out the private sector whom we've just kind of left hanging. I am opposed to the thought, we spend a lot of non-billable hours among our attorneys coming up with a way to have people not fall afoul of the feds. And I think to just say, well, we're not actually doing anything until the end of whatever multiple years judicial fights. I don't like that part, but I'm still a no.
Thank you. Madam Minority Floor Leader Conley, first time.
Thank you, Mr. Speaker. I too will urge a no vote on the concurrence. And for another reason that I hope the concurrence committee takes a look at. Honestly, I liked what we did with the definition of public entity that the Senate removed. And I'm not confident that they took care of it well enough with some of their other subsections. We made sure that a public entity that is receiving federal funding would still be protected. They put in a caveat, it looks like, on an E, but I'm not 100% sure that it did what we intended it to do. And so I'd add that to the list of things to have a discussion about with the other side. Thank you, Mr. Speaker.
Any other member, first time on the concurrence? Chairman Nicholas.
Thank you, Mr. Speaker. On and against the bill and in favor of the motion to not concur. Ladies and gentlemen, I'm just reading through the language in the resolution that's been created. And quite frankly, there are things in that there are inaccurate statements of law. And it's one thing saying what a position is, but this is articulating and saying this is what the law is, and so this is what you have to do. In addition, and one of the things it talks about is that they don't have the federal government doesn't have the authority to do any COVID mandates to manage the well-being of the United States. Well, they do it with measles, they do it with smallpox, they do it with polio. And so the idea that we pull this out and treat it uniquely in and of itself, it doesn't make sense to me, because they have the authority to do it on those other ones. So we know through past acts of the United States, they have the authority to do it. What I think this needs to be rewritten if we want to have a resolution to state more accurately and more legally the grounds that we object to it. And so, I've got about 6 different scenarios of issues that I've got listed saying why this language, why this. The fact is that we need to work this bill. We need to think about it. If we, instead of just adopting this language and throwing it out there, or at least our committee ought to do it, because we're signing off on something that we haven't. I mean, I just read it in the last 15 minutes, and the idea that we concur on something that without studying it to begin with, I think is probably not apropos.
Thank you very much. Representative Yin for your first time on the concurrence.
Mr. Speaker, thank you. So I think you guys know how I'm going to vote, but I do want to point out, I think there's an issue that the Senate created with their new language where we wait until all resolutions and judgments are done, and then the law could be enforced. So I would ask that if we do vote no on concurrence, that any conference committee assigned asks our contractors or anyone else who falls under OSHA, frankly, on whether this still risks OSHA primacy with the language that's in the bill. So if, for example, we have all the court cases, they're resolved and they say, the OSHA rule specifically is constitutional. Just if you assume that happens, then our law becomes enforced, right? And then we won't enforce laws that conflict with the federal government, but that doesn't mean that we as a state government are still willing to enforce the federal rules, even though they are in conflict. So I do worry that with the language that we still have, that there's an OSHA primacy conflict. The other ones, I don't think it really creates that conflict, but the OSHA primacy one, I would ask any conference committee to inquire about that before going forward with bringing back a new message to us. Thank you, Mr. Speaker.
Thank you. Any other member for their first time on concurrence? First time on concurrence, anybody online? I am looking at the screen. I don't see any hands. All right, first time on the concurrence. Representative Henderson, thank you.
Thank you, Mr. Speaker. Against concurrence and against the bill right now, frankly, it's not anywhere near like what it was when we sent it over to the other end. And I know they tried hard, but I would just ask yourself, is this really one bill or is this multiple bills? And I hope we can fix this. I'm not sure we can, but I hope we can. It was fixable when it went over. Thank you.
Thank you. Any other member on on the concurrence report? Excuse me, on the concurrence? Any other member on concurrence for the first time? Representative Sweeney.
So thank you, Mr. Speaker. My question is, did this, and I truly don't understand this, so if somebody could explain to me, did this change it into virtually a resolution that has no merit and no standing in the courts? Because when you interject into what I thought we sent over to the other end of the hall was in pretty good shape. Now it appears all of a sudden halfway through the bill, they've interjected a resolution. So what do you end up with at the end of the day to the 7 attorneys that are in this body? What's your opinion? Thank you, Mr.
Thank you. Any other member for their first time? Members for their first time? First time, second time before the sponsor or before the explainer. Second time before the explainer. To the majority floor leader, Representative Summers.
Mr. Speaker, thank you. Just once again, vote no.
So members, we are voting on the motion to concur with Senate amendments to House Bill 1002. A majority of the elected members is required. Chief Clerk, please call the roll.
Andrew. Baker. Banks.
No.
Bear. Blackburn. Brown. Burkhart. Burt. Clausen. Connolly. Crago. Duncan.
No.
Eklund. Air.
No.
Flitner.
No.
Fortner.
Yes.
Aye.
Aye.
Aye. Gray. Greer. Greer. Hallinan. Haroldson. Harshman excused. Heiner. Henderson. Jennings. Kenner.
No.
Knapp. Larson Lloyd. Larson Dan.
Aye.
LeBeau. McGuire. Nyman. Newsom excused. Nicholas. Oakley.
No.
Obermuller.
No.
O'Hearn.
No.
Olson. Ottman. Paxton. Provenza. Rodriguez Williams. Romero Martinez. Roscoe.
No.
Schwartz. Sherwood. Simpson.
No.
Summers. Stith. Stivar. Sweeney. Walters. Washit. Western.
No.
Wharf. Williams. Wilson. Winter. Ginn. Zawanitzer. Mr. Speaker. Closing vote. Are there any changes? Closing vote. The vote is closed. 11 aye, 47 no, 2 excused.
Members, by your vote, you voted not to concur with Senate amendments to House Bill 1002, which was message 1105. Okay. So members, I'm going to appoint the conference committee of Greer, Summers, Chairman, Swanitzer. Greer, Summers, Chairman, Swanitzer for House Bill 1002. And members, because what we have to do now is our message has to go to our colleagues down the hall, and then they'll have to appoint a conference committee should they wish to. We're going to have a lapse in time. So I think what we're going to do is the majority floor leader is going to set a time that we anticipate the Senate would have received the message and have appointed a conference committee and be ready to confer on the bill. And so we're gathering a room number so that we have a place so that for that. So Mr. Majority Floor Leader.
Mr. Speaker, thank you. The Conference Committee on House Bill 1002 will meet in West 113 at 3:30.
Thank you, Mr. Majority Floor Leader. So members, that gives time for the message to travel, them to do their appointees, should they wish to, and then for the committees to meet. So the public is on notice, obviously, and so are you as well. So with 3:30 being our conference committee time, is there any further business, Chief Clerk? And no messages? Okay. So the House will stand in recess until 4:30. 4:30. The House will be in recess till 4:30. Again, 3:30 is the announced conference time should the Senate appoint conferees. Thank you to those online. 4:30, we will reconvene, potentially with a report. Thank you. The House is